What is up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. Yes, that is me in the corner there written over. I don't know if you'll see me clearly. We're going to talk about some class action lawsuits that are going on with LVNV funding. Some of them may be settled, but this opens the door for you to be able to see if they have done something improper so you can get that collection not only removed off your credit reports, but potentially you might be able to get all of the debt forgiven without a 1099-C, so they can't try to claim that they forgave the debt. And then because they violated, if they violate, they can't just say, we're going to send it to the IRS for 1099-C debt cancellation. No, the debt collector cannot do that. So we're going to go over some of these class action lawsuits, look at some of the openings that I believe may work in your favor if you have collections with LVNV, and if some of the other debt collection companies were attached, but we're going to be focusing on LVNV for the purposes of this video. LVNV Funding LLC. So here's the first one here. LV, and this, you can go to classaction.org and see all of this stuff. I just be scrolling and reading and seeing what's going on, and I make updates to the way that we attack with our letters going to debt collectors. So here's one here, interesting on what happened in New Jersey. All right, let's see. The first one here, we got LVNV funding hit with class action lawsuit over alleged robocalls. Alleged robocalls. For the purposes of the class action claims, LVNV funding has overstepped the Telephone Consumer Protection Act (TCPA) by placing robocalls to consumer cell phones without securing prior express consent to do so. They can do that now. This was before the law change. That's why they fought hard to get the law changed to where they can text you and they can also hit you in the DMs on your social media account. According to the case, they collect routinely place calls that
Returning
feature
visitor.
an artificial or recorded voice by an automatic telephone dialing system, ATDS, that can place calls in mass without human. Look at that, in mass, Latin, right? Without a human intervention. The lawsuit argues that this practice violates federal law unless the caller has secured the recipient's express written consent to be contacted. So this was one. They did this in 2020. And so what you could do is if you have a collection and it was in the year 2020, you could actually write to LVNV funding saying that you received a robocall and you know that we're in court with a class action lawsuit pertaining to this and that you believe it is a violation, and you can put your remedy that you would like, which is to just get to actually cancel the debt, not a debt cancellation. This would be where they just won't be coming after you and they write a letter stating that they're not going to come after you for that debt. You don't even want a 1099-C. They might try to pull that on you, but you don't even want it. Okay, here's another one here that caught my attention. We got FBCS. We'll learn who that is in a second. LVNV funding faces class action lawsuit over alleged improper debt dispute instructions. So what we have here is LVNV funding staring down a lawsuit that alleges that the company failed to provide a New Jersey consumer with proper instructions on how to effectively dispute his debt. You always have a right to dispute a debt when you get it from a debt collector. You have a right to dispute a debt from an original creditor, but that's only if you believe something really happened with the original creditor. With a debt collector, you have a right to do a dispute because you never had a contract with them. You want to get everything: contract, privacy, information exchange with the original creditor, balances, accounting, everything. You want them to prove 100%. Now, for this one, it was just a T-Mobile bill, so you would want them to show how they got that amount from T-Mobile. But what this whole case was about was that they did not, over the phone, they told the person, okay, we're going to look at it and see if this debt is yours. But that's not the way it's done. And I know everyone hates hearing this sometimes, and the bureaus, and there's other people out there telling you to do this electronic. But the way that is going to be the most effective way to dispute, and the proper way, the only proper way to dispute something with a debt collection company, is to do it in writing. If you don't do it in writing, they're going to disregard it and they're going to move their case forward. And that shows you the proof right here. With this case that was filed, they did not uh, tell the customer that just because you're disputing it with me on the phone does not mean that it's disputed. So you got to put it in writing. Let's go to the next one here. We got Lvnv funding, resurgent capital, improperly reported settled accounts as in collection with unpaid balances case claim. I see this a lot. This is where, basically when this type of stuff happens is they forget. Even when they settled an account, they did not go back and correct that information. When you settle an account, debt collection companies can do one or two things. They can either remove the whole thing off of there, and some of the times they will, some of the times they won't. Uh, or they need to update it and they need to say that it is paid and it is a closed account, not open with a zero balance. They need to do that. Either which way they do it is not going to hurt you on your credit reports if they do that. If they don't do it, then they're falsely stating your credit history. If you paid it and it was formerly a collection, they have to correct that within a 30-day time frame. Now they might try to say, hey, we do our updates and you did it at the beginning of the month, and now we got to do our when we do our updates at the end of the month, it would have been reflected. Well, what they're showing on here is that it did not reflect even after that period of time that went by. And you can see the connection. Resurgence Capital, all of these companies work together. Usually, the big company, Lvnv, Resurgence, Sherman Acquisition, these companies will buy them and then they'll push them down too. So I'm pretty probably Resurgent bought it. Lvnv was the company that was actually doing the collection. All right, let's see here. Another Lvnv, and you got Dynamic Recovery. This was misleading settlement offer. Okay, when you get those letters in the mail and they're going to say that, hey, we would like to settle this account. So let's just read this one here. Dynamic was probably who they were using for the state of Texas. That's where this one was. It says Dynamic Recovery Solutions LLC, Lvnv Funding LLC are on the receiving end of a proposed class action lawsuit that takes issue with an alleged misleading settlement offer made to a Texas consumer, which it was probably done to many, but we'll just say alleged, like they say. According to the lawsuit, the defendants sent the plaintiff a collection letter in which the agency presented the man with three options. Have you seen that? I've seen it. They do this three option type deal. The second option, the case explains, allows the plaintiff to resolve the account for $933.09 to be paid in two installment payments. The suit argues that the two payments added up to 910 cents, which is higher than the settlement amount offered through the difference is only, though the difference is only 1%. 1 cent, however, the complaint reads, no matter how small the amount is, defendant is simply not entitled to collect an amount different than that is stated on the settlement offer, and it's false statement and misleading. So look at that, for 1 penny. Now, let's flip that over the other way. If it was the debt collector, say you had $1 and I've seen this happen before. Customer made a settlement. They were making payments and they did not pay the right amount by $1 on the second payment. And the debt collector said that it was not paid in full. And they actually tried to go to the full account, not a settlement amount. And this really did happen. This was a number of years ago, but this really did happen. Payment number one was good. Payment number two, they accidentally did it for $1 less. And the debt collector said, we're not going to go through with the settled amount. We want to get the full amount. And they thought that they were going to be able to just bully our customer at that point, but we said no, that was just a mistake, and you need to leave it how it is. But believe it or not, they pushed for about 3 days before they accepted that other payment with a check. That I mean, a cashier's check, because I don't even allow my customers to send checks to from their checking account. A cashier's check
New
for
visitor.
$1. It was a money order for $1 for the remaining amount. But they will pull that. You got to be careful with debt collectors. What they'll try to do, they'll have that 10-day rule, 14-day rule, where if they don't get the payment within the 10 days or all of the payments within the 10 or 14 days, if you had it separated, or within your agreed period of time for the settlement, some debt collectors will try to cancel out everything and try to revert it back to the full amount. And so even though it was one penny, they have to follow the rules because they try to make other people follow the rules also. Let's go to this one here. New York consumer, a lot of this is New York. New York, I told you, New York actually has some very good uh, uh, debt collection rules that they have to follow. One of the ones that they have to follow is that they cannot just come to you with a statement, a previous statement. They actually have to get more the information from the original creditors to be able to prove that you have to pay a debt in the state of New York. Okay, so we got Foster and what is that group? Garbus, LLP, two of the firm's attorneys, Lvnv Funding, LLC, Sherman Financial. Remember I said that they were connections, Sherman and Resurgent, are the defendants in a proposed class action filed by a consumer who alleged the companies engaged in deceptive, misleading debt collection practices filed in New York. The lawsuit takes issue with the letter sent to the plaintiff by the attorneys. According to the suit, the letter listed $873.61 balance due as of October 19, 2017, and stated in part, if you don't take advantage of this offer, interest may be subsequently occurred on this account. The case argues that the letter has misled the plaintiff in that it implied her balance would increase should she decline the offer when in fact it would not. Further, the suit claims the defendant failed to clearly convey the woman's amount of debt by neglecting to explain this basis for accrual of any interest. And here's a lawsuit. But basically, on this one, uh, I could see a huge issue with this here, where they would just say, because are they saying that this was the total amount? So they say balance due, and then they said uh, that she would have an increase in interest, which you can't do. If you buy debt, you can't start saying an interest on there. Now, after you have a judgment, you can start, in some jurisdictions, not all, you'll be able to add interest onto it, but I haven't even seen that in all states where they've been adding interest. They just, because they're buying this for pennies on the dollar. So most of the time they just still go after that same amount plus the court fees. All right, let's see what else we got here. Lawsuit claims First National Collection Bureau, Lvnv funding, misled consumers in unlawful letter. And I always talk about, remember, and I'm gonna get you that letter that I talk about all the time in my videos. But I talk about, if you're gonna really stop a debt collector, if you and they know that they mislead, they're what they're trying to do is they're trying to make their letters to make people believe that they're going to be able to come after them, and because with them the first strike is that letter, is they're going to have the most ability to be able to collect from someone before taking them to court. So they try to make that first letter as scary as possible. And I always tell people you need to make the letter to respond to them, to let them know that you know some things that they don't think that you should know. And so we look here at a proposed class action alleges that First National Collection Bureau, Inc. and Lvnv funding failed to comply with the Fair Debt Collection Practices Act (FDCPA) by conveying false and misleading information in a debt collection letter. Uh, the plaintiff received a letter which was sent by First National Collection Bureau on the behalf of the current creditor, Lvnv Funding, in April 2018 regarding a debt originally owned by HSBC Bank Nevada. They bought the debt. The letter alleges listed a total amount due of $12,622.61 and indicated no interest had accrued on the balance since the debt was charged off. The defendant, however, also included a letter contra- contradictory information that may have suggested otherwise. And let me tell you how this could have happened is that they might have sent the statement after that, and the statement showed a different amount. According to the suit, the notice contained all unlawful language that stated in part, this is to advise you that a judgment has been entered against you. The judgment against you has been placed with our office for collection by our client Lvnv Funding LLC. Language failed to disclose any specific information regarding the alleged judgment. The complaint says con- leaving the plaintiff confused as to the status of her debt and what interest or fees have been applied according to the lawsuit. The letter also stated the following. Because of the interest that may vary from day to day, the balance owing on a day-to-day you pay may be greater. The complaint notes that generally applicable post-judgment annual interest rate is 9% in New York. The suit argues that if a judgment had in fact been entered, an interest rate of 9% would have been accruing on the debt balance, meaning the prior indication that no interest had accrued on the debt was false. If, on the other hand, no such judgment had taken place, the suit argues that the defendant falsely claimed that the debt balance may be increased due to the accruing interest. Moreover, the suit argues that the threat of a balance increase overshadows the plaintiff's rights to dispute her debt by pressuring her into making a timely payment. The purpose of the class action lawsuit that the contradictory, unclear, deceptive language of the letter violated the Fair Debt Collection Practices Act and misleading the plaintiff. So they did not make it clear in here if they did get a judgment. So, but what they're basically saying is that if they got a judgment, then 9% uh, would have been added onto the balance, over a period of time. It would have been 9%. And they did not state it. They just stated that it didn't. More than likely, this was never a judgment because she would have been notified if it was a judgment. And they tried to scare her into thinking that she had a judgment. I've seen on some letters where they don't actually say that it's a judgment. They would say that they would be pursuing a judgment, which is where they're actually threatening to take you to court, which is a violation of the Fair Debt Collection Practices Act. They cannot threaten to take you to court if they do not intend and take you to court. The only thing about that is that it is very vague on how much time they give them to take you to court. Um, but they're not allowed to say that they're going to sue you if they don't sue you. So I would say that if any debt collection attorney or lawyer or company says that they're going to sue you, if they haven't done it and have it recorded that they're going to do it within 30 days, I would send them a letter saying that they violated the Fair Debt Collection Practices Act by falsely claiming that they're going to sue you. Now, you might be saying, well, I don't want to get them to come and sue me because if they had a debt, they're going to come and sue you. Well, that's the chance that you have to take on your own. I'm not telling you to do it. I'm just saying that that's the chance that you got to take on your own. If you feel that that they violated the rules, you're going to have to take that action. And even if you feel that they violated the rules on anything, that a debt collector violates the rules on anything, you're going to still, if you're going to win anything, you have to get an attorney, and you're going to have to pay that attorney, and you're going to have a chance of winning or losing. So no matter what, you're going to have to be playing the game of possible winning and possible losing. The way that I make my moves is that if I have all of the information and then I'm willing to accept the consequences on both directions, then I would be willing to move forward. And I think that if they did not sue, say that maybe your temperament is saying 60 days, that if they threaten you 60 days ago to sue you and then you call the courthouse and there is no lawsuit there, you could craft a letter with the specific line from the Fair Debt Collection Practices Act that says that they cannot threaten to sue you without suing you. Time frame, that's where the gray area is going to be. You can send that to them. But if they said that they're going to sue you and then they haven't sued you within 60 days, I would think that they're not going to sue you, that they've probably looked at your situation and they said that it's not going to be worth trying to sue you. All right, I'm going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. That's where I show you our process with repairing credit. Also, it's not just about credit repair. We have clients that come to us and they're trying to buy a house. They're trying to move themselves forward, stop renting. And there is a specific thing that you should know about if you're trying to buy a house. You cannot have disputed items on your credit reports if you're trying to buy a house. And so what we do when clients identify that and tell us that is that we just move them straight into a settlement process. That's going to be where, rather than disputing anything, we're going to go straight to those furnishers and we're going to try to work out deals with them so they can be paid, removed, or just paid and closed out, and then the person will be able to buy their home. You cannot, and I repeat, if you're going to buy a house, you cannot have any items in dispute. They must be either resolved or not disputed anymore, because that's just the way that the underwriting process works. If you need your credit reports and scores, go to the website scores.com, and you can get all 3 credit reports, all 3 scores. And now for the letters that I talked about, for the first one where you want to hit the debt collector back, if they send you that letter, is first you got to know if that debt is past the legal statute of limitations to collect. If it is, then you just use letter number 1, my statute of limitations letter. Make some, put your information in there and notify them that they're attempting to collect a debt that's past the legal statute of limitations to collect. Next thing is, if it's not past legal statute of limitations to collect, you can go to my website, thecreditrepairshop.com, and on my blog, search statute of limitations, and the page will show up. Column 1 is for regular loans. Column 4 is for credit card debt or revolving type accounts. Statute of limitations can be different for those in your state. Once you find out that it's not past legal statute of limitations to collect, then you want to use the cease and desist collection activities letter that I give you. That will stop a lot of debt collectors from coming after you if they don't have all of the information to come after you for a specific debt. And then I give you a debt validation letter just in case you need that, because there's going to be some back and forth with the furnisher of that information. All right, I'm going to end the video here. Please make sure that you subscribe to my channel. You can comment. I've been answering some of the questions in there. And make sure that you like this video. I really appreciate it. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com. Thank you.